All right, I think we'll get started. Thanks to everyone for joining us for the last panel of the day. And the organizers have asked us to announce that there will be no closing plenary. The panel originally reporting back from the work groups has been canceled, given that each working group has a session. And so after this, we are finished. So this workshop is entitled Good Policy Practices in Online Freedom. And our hope is to get a bit more specific about the theme of this year's Freedom Online Conference, and also about some of the commitments that the Freedom Online governments have made in the Tallinn Agenda. I'm thinking about, for example, the obligation to adopt and encourage policies and practices nationally and internationally that promote the protection of human rights and fundamental freedoms online, and the statement in which the governments call on governments worldwide to promote transparency and independent, effective domestic oversight related to electronic surveillance while committing ourselves to do the same. Our goal is to identify a few concrete examples of good policy practice that Freedom Online members could adopt in order to ensure the right to privacy in communications. We've decided to focus on privacy in order to have a good substantive discussion in a limited period of time. And given the importance that this issue has taken on in conversations about online freedom, and in this conference in which 6 out of our 10 government and intergovernmental speakers this morning commented on the need for policies on the right to privacy that are consistent with international standards, and we're specifically welcoming the creation of a new UN Special Rapporteur on the right to privacy. My name is Liesl Brunner, and I am the facilitator for the Telecommunications Industry Dialogue. It's a group of telecommunications operators and vendors who address freedom of expression and privacy in the context of the UN Guiding Principles on Business and Human Rights. We are currently engaged in a 2-year collaboration with the GNI, which has involved sharing best practices and is also looking at perhaps bringing these two groups together. And we'll have more information on that in the coming months. The members of the Telecommunications Industry Dialogue have stated their aim to disseminate information on the legal frameworks that apply to telecommunications companies and that affect the rights to freedom of expression and privacy. And last year, Vodafone issued its inaugural law enforcement disclosure report, which was accompanied by a legal annex, which included information on laws that affect these rights and apply to telecommunications companies in 29 countries of their operation. And they updated this with laws on freedom of expression in February of 2015. Some of our other companies have also started publishing information on the laws that apply to their operations. And the Industry Dialogue will itself be adding to this, this list of countries and legal frameworks within about a month or so. Our hope is that civil society, academics, and other interested parties can take this information and use it in their work, in their advocacy, in their efforts to understand how telecommunications companies operate and how laws affect users' rights to freedom of expression and privacy. So in preparation for this panel, we chose 3 examples from the Vodafone report that present some examples of good policy practice. They are not the only examples or the best examples, perhaps, of good policy practice, but we considered that they were worth taking a look at. So we chose the Czech Republic, Germany, and Portugal. And panelists in the audience are welcome to cite some other examples. And drawing on international standards, we've all agreed on some good policy practices that we would put forward to the Freedom Online Coalition governments, and we're eager to hear from you as well. For our panel today, we have Brett Solomon, the co-founder and executive director of Access. We have Dr. Katrin Niemann-Metcalf, the head of the chair of law and technology at Tallinn Law School at the Tallinn University of Technology in Estonia. And we have Judith Lichtenberg, the new executive director of the Global Network Initiative, who was also previously at Vodafone Netherlands. So I will start out by asking Brett to tell us a little bit about the international principles on the application of human rights to communications surveillance, which Access was very instrumental in drafting and has an update to share with us on. tell us a little bit about the principles and some of their most important points that are relevant to our discussion of good policy practices.
Thanks. And special welcome to Judith as the new head of the GNI, which is a great development, and really pleased to be here on the panel. Thanks a lot for inviting me. And thanks also for drawing attention to the necessary and proportionate principles. Can I just get a show of hands? Who is familiar with the necessary and proportionate principles? Oh, great. Perfect. This is an opportunity to tell you about them. So we've been talking a lot over the last day, or since this morning, about the privacy implications of communication surveillance. And I think everybody in this room is probably concerned about how states and also companies are operating with respect to the protection and at times the violation of the right to privacy of users and of citizens. And so part of that, I think, has happened because, well, for various reasons, but one reason is that I think there is an insufficient norm development process that's taken place over the last couple of years, i.e. what are the standards that need to be in place to ensure that users who are handing over very significant amounts of information about themselves to platforms, what is their expectation in terms of the protection of that information, and what kind of rights do they give to the platforms to actually store that data and also to have that data accessed by third parties like states. And so the necessary and proportionate principles are basically a set of 13 principles that have been developed since 2013 that provide guidance to states, to companies and to citizens about how can communication surveillance take place in the context of protecting and respecting human rights. So I think probably all of us in this room are under the expectation that some form of monitoring of the networks will take place in the context of criminal activity or in the context of national security. Would that be right? Is there anybody here who would actually think that there are no circumstances in which security or law enforcement should be able to have access to the network? So in which case, and I'm not sure if my question is clear, and I didn't actually anticipate to ask that question, but here we are. So given that everybody in the room thinks, probably, that there are instances where law enforcement should be able to access user data, what are the conditions under which that can take place in the context of respecting the human rights of the user? And that's where the necessary and proportionate principles come in. 400 civil society organisations have signed the principles. That's 400 civil society organisations from every region in the world. I'm not sure about Mongolia, but certainly civil society organisations in Mongolia should have a look at the principles and see whether they're relevant. And what we are actually launching today is a thing which is called the Implementation Guideline for the Necessary and Proportionate Principles. So isn't it awesome to have principles? But what do principles mean in reality? How do you actually ensure that when law enforcement goes to access the data of a user, that they're actually following the principles in practice? So when we talk about, and I'll give you one example, the first of the principles is legality. Does the entity that is requesting the data of the individual, do they actually have the legal right to ask that? i.e., is there actually a properly constituted law that gives the National Security Agency the ability to be able to access or request from Vodafone, for instance, that information? That's principle number one. Principle number two is there a legitimate aim? i.e., are they actually asking for the user's data because there's a national security concern, or is it because they actually want to find out who is responsible for publishing content that is in opposition to the government? So that's the second principle. And so this implementation guide goes through the process of the request, happening from a security agency all the way to review. So how do you properly ask for a user's data? How does a court properly consider whether that data should be made available? And then when the company is handing over, what are the proper processes to ensure that the company can be assured that there's a request that respects the user's rights and is actually necessary and proportionate to the stated aim. So I might just stop there. Sure. But I'd like to talk about this more if people are interested. I have copies of the implementation guidelines. This, in a way, is saying to all of those entities that are out there, when they're wondering what steps can be taken, this is a very, very clear set of guidelines that can be used by national security agencies, by companies, and by civil society to hold both companies and governments to account.
Great, thanks for that, Brett. Katrin, you have considerable experience advising developing countries and international organizations as well in developing norms for governing online freedom, media and communications laws. Tell us a little bit about, are there such a thing as international good practices, and what are some of the challenges to developing international good policy practices? Yeah.
Thank you for that. Yes, I've worked in, I should actually count sometime, but in more than 40 countries anyway. And don't think I've been to a single country where one of the first things that I hear is not that we are unique. We are not like any other country. So how can you come and tell us about these international principles? And I totally agree, every country is unique, and it should be unique. And still, I think it is extremely relevant to talk about principles. But it's very important to do it in the correct manner. And I don't really believe in the idea of, which unfortunately happens quite a lot, both on the side of international consultants and on the side of governments and, say, the receiving states, that you look at legislation from another country and try to copy it more or less. Like it looks, in some areas, this may not be such a bad idea, because we have certain areas of law where history has just developed in such a way that the legislation actually looks extremely similar. And I'm thinking maybe primarily of competition law, that I think any of you who's ever worked with competition law, you can pick up the competition law of any other country you know nothing about and you will recognize it instantly. It all comes from one same history, from basically the spreading of the railways in the United States of America in the end of the 19th century, and from there it's developed all over the world. But mainly in areas also where we perhaps talk more about principles of individual freedoms and cultural differences, and so then this is very difficult and not even a good idea. So that's why it's very useful when there are actually documents available that are dealing with principles on a principle level, because otherwise what we have to do, what we for instance do, because I also work a lot with e-governance, which is our Estonia speciality, and we get asked by countries basically all over the world to come and share our experiences of e-governance, and there are no international legal norms as such on e-governance, so what we have to do is to really tell our Estonian example, but what we do then is that, the way I like to think about it is like an artichoke. I don't know if you eat artichokes, but if you do eat artichokes, you need to get to the good bits. You need to peel off layer after layer that are sort of insignificant. And this is in a way that the way one has to deal with the legislation, that we have to see this Estonian legislation as it is then as the artichoke, on which many of the bits are actually relevant for some purpose. I'm sure every bit of an artichoke has some purpose as well, but not the core is only what is relevant for somebody else to look at, because that is where we have these principles. And that's why these principles, like what you were talking about now, Brett, is excellent, because you've already peeled off the core and you've kind of, peeled off the rest and come to the core of what it is that one can use in different countries. And I will just take a couple of examples from these countries that were mentioned as in the material that's been spread as well, of what I mean with these kind of principles that can be used even in countries that are very different. For instance, it says in the Czech legislation that it must be reasonably presumed that the surveillance and recording, and I'm not quoting exactly now, just abbreviating it a bit, but it must be reasonably presumed that surveillance and recording will obtain important facts. And this is a principle, it's very basic, but actually the fact that you have to think about that before you take a decision, I think is quite relevant. And I think this can be done everywhere in the country. It doesn't, the fact what it is that may be relevant and how, to what extent do you actually need such surveillance, that may vary a lot depending on the security situation of the country or something, but that principle is such a thing that there's nothing culturally specific about having such a good principle. Proportionality is something else, actually. I mean, to the very core of it. I mean, everybody can be proportional, but what is proportional is extremely different from one country to another. But the fact that you are to be proportional is actually the same. I'll take another example, actually, also from the Czech Republic. The way that the system for oversight looks on a quick reading of the legislation, and the fact that it's a quick reading of it is actually significant because it shows it is easy to understand. It looks very much the same for different types of requests. So whether they come from the police or whether they come from the military, but it is still similarly expressed and it's a similar form of oversight, which means that for the companies it would be reasonably easy then to understand what this is. Again, a principle which as a principle can easily be adopted by others, even if the fact that we're here talking about a certain type of a judge in the Czech Republic, of course, is not relevant. So we don't copy that bit, but we copy the idea that let's not make 10 different forms of oversight, but let's try to make this as simple as possible, because that makes it understandable and hopefully also more easily implementable. So I think I will also actually stop there, because it would be more interesting to have questions and comments and also to hear from the company view.
Thank you. So Judith, prior to coming to the GNI, you were the head of regulatory affairs and digital rights at Vodafone Netherlands. Give us a bit of your perspective from that experience on challenges to companies in trying to respect the rights of users to privacy, and how, how good policy practices really plays a role in that.
Yes, Liesel, thanks. You mentioned already in your introduction that I'm the new director of Global Network Initiative. It is my 3rd week, so it's a real pleasure for me to be here and to be able to start my job in such an inspirational setting. Let me first say some words about GNI. GNI is a multi-stakeholder platform. It brings together ICT companies with civil society organizations, academics and investors to work on a common approach on the protection of freedom online. And GNI was created to solve the problem of companies facing conflicting requirements between domestic laws and international laws. And our aim is to help ICT companies to respond responsible to government demands that actually, well, you could say are violating international norms. And so one of the first things that GNI did was to provide a framework for the ICT sector of principles and guidelines to guide them. And there was really a need for such a guidance. And even today, when you see the developments with, on the one hand, the revelations of Edward Snowden, on the other hand, also issues in the Middle East with ISIS, that really puts new pressures on companies in this field. And so what I would like to do today is share some of my experiences with the challenges telcos face, to illustrate actually why we need good policies. And I would like to focus on 2 items. Legitimacy, we definitely need better laws, and transparency. We also need more transparency both from governments and companies. So maybe I can start to give a little context about telcos. Telcos have traditionally very strong ties with governments. Many telcos were first state-owned. In developed countries, they are liberalized, but in many other countries, telecom providers are still state-owned or partly state-owned. And they are working on the basis of licenses. And those licenses are issued by government, so there is also dependencies. And telcos, often when it comes to privacy, security, and freedom on online issues, they feel caught between conflicting forces. So on the one hand, they need to protect the privacy of their users. It's crucial to maintain their trust. On the other hand, they have a legal obligation to comply with a request from government for data access. And, well, Brett already said it, few people will criticize governments for the legitimate use of ICT tools to combat crime and national security threats. But it becomes tricky when governments misuse those tools. And then telcos also get in trouble because they really face to be associated with human rights abuses. And challenges, for example, telcos face in countries are situations where local authorities don't comply with legal requirements themselves. So, for example, the requests they issue are not in writing, the authorities who issue the requests are not competent, they ask for information they are not allowed to ask. I'm sure everyone knows the example of Vodafone in Egypt, but to give another example, in January 2011, there were some people shot in Albania. They were demonstrating at the office of the Prime Minister. The people were opposition members. They were shot by the national security forces. Well, there were some accusations from political faction who was behind the shootings. And then the investigative authorities asked for data from all the telecom operators. They weren't allowed to give those data. And then it really became nasty when they actually refused to provide those data. And so personnel had to come to the police office. They were threatened. They were held and kept separately. So this example also makes it clear that personal safety plays a role. But the biggest risks are, of course, when national laws are violating international norms. It's definitely not something that only happens in countries where you have repressive regimes. Just a well-known example is the European Directive for Data Retention. It was adopted in 2006 in the aftermath of the terrorist attacks in Madrid and in London. It was hugely criticized, and I think the worrisome part was actually that at the moment the European legislator adopted this directive, it was clear that it was in violation of international norms. And so last year it was indeed declared invalid. Well, it was also mentioned here already by Liesl. For Vodafone, the events in Egypt were really, to put it mildly, a wake-up call. So last year we published a report on government surveillance. And one of the things that was revealed by Vodafone was that in 6 countries where they operate, they have to give direct access to their networks. And so basically all telecom providers in those countries are obliged to install a direct pipe to the network, or governments are allowed to do that themselves. And those access don't require any warrants. So what it basically means in practice is that governments can do what they want. They can do mass surveillance, and telcos have no idea what happens on their networks. That's definitely a clear violation of international norms, not only in a very practical sense. There is a norm that networks from public providers and legal enforcement agencies should be physically separate. But of course, it opens the way to practices that can be violations of privacy and freedom of expression of individuals in itself. So maybe I can just leave it here.
Okay. So we've heard from many different aspects of this conference and many of the different discussions and plenaries that there's a great need for government transparency with regard to communication surveillance laws and practices. It would generally be considered a good policy practice, I think we all agree, for governments to draft clear and precise laws that give notice as to which government authorities can conduct surveillance, under what legal authority, for what purposes and by what means, and how these powers are overseen, by publishing statistics on demands for lawful interception and for metadata, and also by allowing companies to publish statistics on the demands that they receive. So I'll just ask the panelists, maybe starting with Brett, for their comments on this as a good policy practice.
Well, I think it's important to look at it contextually. And one thing that we've seen over the last, since I guess 2013, is the beginning of publishing of transparency reports from technology companies. And you know, from a personal perspective, I actually remember going to the Vodafone AGM in 2011 and standing up in front of about 3,000 shareholders after Vodafone shut down the network in Egypt and said, essentially, when are you going to reveal the requests that you're getting from governments that are forcing you to act like this? And there was a response from the chairman that was kind of understanding, incredulous and nervous. and it's great to see as a result of significant pressure from civil society organisations like ours and others, of course, that now it is a norm. I actually think it is a norm that technology companies, telcos and also internet companies, in the context of doing business, to issue transparency reports. And the Vodafone report that Judith referred to, if people have not had a look at it and if it's of interest to you, have a look at it because it's absolutely amazing. I mean, it's 40,000 words and it's incredibly granular, and I think it is a best practice example that governments should look at in terms of the sorts of requests or the sorts of publishing that is required in terms of what's the nature of the request, the why, the under what head of power, the number of requests, the number of requests that were rejected, and on what basis. So there's a whole, I think we've seen from the telecoms, a whole series of learnings that the governments should take into account when they start to issue their own transparency reports. Peter Misek on my team talks about dual accountability, i.e. you have all of the telecoms and the internet companies plus all of the governments also transparent, and then you can also look at the whole sector. Because at the moment, all we can see is what sort of request does Vodafone get and what sort of request does Facebook get, but we don't know from the rest of the tech sector, and we also don't know from any of the governments. So it's something that we're definitely in support of. I should just say, and it should start with the Freedom Online coalition countries. This is where it should start. This is exactly what we require, is transparency from these governments, because their activities, when they talk about freedom online, it's not just about freedom online overseas, it's about freedom online in their own countries, including mine.
Yeah, no, I'm very happy to pick up straight away there, because again, if I work more with governments than most of these projects I do are for governments or through international organizations supporting governments, and it tends to be in developing countries to some extent, but actually mainly it's been post-conflict, or even countries that are not even post-conflict, but I worked with Afghanistan, Somalia, Nigeria, earlier than with Bosnia, Kosovo, etc. And it's, to come back to what you said initially, it's not places where one can say that there will never be any need for any special measures. That's not the reality of those countries. And it is important to recognize that we cannot have the kind of systems there that those of us who are fortunate enough to live in stable democracies can have. One needs to recognize that, and then to see what can then be done to do as good a regulation and as much respecting all the rights as possible. And there I think transparency is absolutely key, and legality. So these are the things which you can have. You can have then special measures that are more restrictive of certain human rights, so because they are actually justified, but there is no excuse for not justifying them. And I think if regulators, governments, whoever have to be transparent, then this is a way that they know they have to explain everything they're doing. The measures may be draconian. You may have to have a curfew after 7 o'clock in the evening, but if you have to be transparent about this, if you have to then constantly explain, and etc., then this is indeed extremely important. And also with the legality, so building up these regulatory systems, it's something which, again, is incredibly important, is saying, yes, you may not be able to have all these best practices that you would like to have immediately, or so you working towards it, but you can immediately have a legality that everything you do is based on law, it is necessary and it's proportional. These are the principles established by the European Court of Human Rights, but they apply all over the world just as well. It's just that it's different what is necessary and proportional in Somalia than what it is in Estonia. And just I'd like to also pick up a little bit on a point you made. Extremely important about this international work then as well is actually to help countries to best implement international principles and conventions which may exist. As I said in the beginning, there are certain areas where there are no international conventions, but there are also lots of areas where there are those, should be implemented, but it is not obvious how to implement them. And there again, the European Court of Human Rights is a good example. Here we're talking of democracies in Europe, and we wouldn't have all of that case law in the European Court of Human Rights if it was evident what these good principles mean. So that is also something which is important to sort of have a discussion, and especially in this area, the communications area, this multi-stakeholder discussion is really important. So we actually make sense of these beautiful principles. Thank you.
Yes, I also think that transparency is crucial for accountability. From Vodafone Netherlands, I also worked on the report Vodafone issued last year. And, well, a couple of learnings there. First, when we made a review of all the laws in the countries we operate, it became very clear that it's very difficult sometimes to get the laws. So I think we need also transparency on the laws itself, so they should be accessible. Then I'm not sure if any one of you have read the Vodafone report. It's definitely not something that reads as a thriller. It is actually quite tough. But that also made it actually very clear that information on those laws and what it means in practice is not available in plain language. You only have the text of the laws themselves, and they are not very easy to read. So in that sense, I think we also need a transparency. And then in the former session, and Rebecca's here as well, she made the observation that we ask from companies that they respect human rights, but to do so we need governments to provide the right legal framework. And I think the report of Vodafone also shows that many governments have stipulated in the laws that companies aren't allowed to be transparent on government surveillance. In some countries, you are not even allowed to say that it exists. For companies, that's a real hurdle. A few years ago, I think also in the telcos, the culture was that you didn't want to share anything because that was quite scary. After all those recent developments, it is an important tool for companies to restore the trust, and so they want to become transparent. And what we did is in every country where it was allowed for us to publish data, we did so. But it also turned out that in many countries the laws are actually not very clear at all where we are allowed to do so. And so we asked for a clarification for the governments. And Brett actually mentioned governments should take an example of all those transparency reports. But we also actually had the following conversations with governments. In some countries, like for example the Netherlands, where it's actually not forbidden to publish statistics, the government really urged us not to publish because they say that it's undermining investigation. They are not prepared actually to explain why that undermines investigation. And so actually it's simply not accepted by citizens. Okay, you should trust us because we say so. But it make it difficult for companies what to do. So it would also be very helpful to have very clear guidance in the law what companies are allowed to publish, so that there is no discussion on that. So I'm also happily in favor of this recommendation and best practice.
Can I jump in? I'm not sure if people noted that Judith was saying that in 6 countries, the security services are actually inside the network, i.e. there's no framework to request data. They actually have a direct pipe inside. And as part of the disclosure, as part of the transparency question, Vodafone and other companies are not permitted to actually disclose what the nature of the relationship is between the telecom and the country. And so they just say in 6 countries. So transparency is awesome because we now know that there are 6 countries in which that takes place. And by a process of deduction, we know which countries they are. And so I wanted to just note that. But the second point is that to pick up on what you said, is that some of them are democracies.
Which actually also makes it clear that laws need to be up to date. And so they need to be reviewed. For example, one of the countries which have very far-reaching powers and which is a democracy is Ireland. But the laws in Ireland applicable today are dated back from the 80s, when there was a terroristic threat from the IRA. So it really also underlines the importance of updating laws.
Thanks, and I'll just highlight that for several of the members of the Telecommunications Industry Dialogue, that problem of direct access to communications networks is present. Several of the companies have tried to be transparent about this, and it's the position of the Industry Dialogue that governments should not have direct access to companies' communications networks, that companies should be able to maintain control over their communications networks, and that requests should come through a lawful process in which a request is received and it complies with the law. All right, I'll move on to the next point. So the Office of the High Commissioner for Human Rights and the European Court of Human Rights have indicated that interception of communications and the collection and the use of metadata constitute an interference with the right to privacy, which must satisfy the requirements of legality, necessity, and proportionality. According to the necessary and proportionate principles, all protected information should be given the highest protection in law. So my question to the panelists is, should similar standards, similar legal standards, govern the interception of communications and the collection and the use of metadata? And we note that in some of the examples that we studied in both the Czech Republic and in Portugal, basically the same standards apply to the interception of communications and the collection of metadata, and both require prior court approval. Maybe I'll start on this end this time, and we'll go this way.
I say very firmly yes, because the distinction between content and metadata is not justified anymore. Simply metadata can be very intrusive, or it is very intrusive, and it can reveal much more than content. And I think it was Edward Snowden who said, as an analyst, I would prefer to analyze metadata because it's quicker, it's easier, and it doesn't lie. So, and I think that's very well true. And especially in those digitalized world, metadata can reveal everything about you. So it definitely needs the same protection as content. And another thing what I would like to address is that what you see in the discussions around data retention, law enforcement agencies stress the critical need for data retention for investigations. And they tend to use the argument that it is only metadata, it's not the content, so it's not that bad. And I think it is very important to keep in mind that metadata is as revealing as is content.
So I totally agree, so I won't repeat that, but I'll carry on with some additional points just to underline the same argument that technology develops very fast. We all know that. So I think this distinction, which can be difficult to be made already now, may become even more difficult to be made and even more artificial. And there comes to mind some words spoken again by the European Court of Human Rights in a different context of biotechnology, but where they said this wonderful line that we have to imagine things that we cannot even imagine. It's this wonderful thought experiment. But what they meant by that was that, and this was actually a case about privacy, so in that sense it's relevant, they meant that there can be uses of this information or data that is collected that may not be apparent today, but that may come because there are so many, and we can just look back for the 10, 20 years and see how much data that has actually become relevant that before one couldn't do anything with, simply because there was no technology to kind of get the information from data, but that may well change as well. And that means that what we're looking for is to protect the privacy of people. That's what's the essential thought, philosophy behind guidelines and principles. So then we shouldn't make different rules for different types of information when there is actually nothing really that distinguishes them when it comes to that aspect. Can this possibly somehow infringe our privacy?
Yeah, I mean, I think I certainly agree. And there's so if you look at what's happening in the US this week, thinking that, you know, it's more than 2 years, or it's 2 years since Snowden's revelations, and there's been absolutely no change at all to the legislative environment in the US. Nothing has happened. Despite all the articles that you've read and all the protests and all the concerns, there's been no legislative change at all. And what is on the table as we speak is a reform of the Patriot Act, in particular Section 215. And there's a reason why the security services are fighting so hard to keep their provision to be able to collect data from the network, including metadata, is because it's so revealing. It's back to your point. It's such revealing information, even if it's not the content itself. And so I think that's just proof of why metadata needs the same sort of protection as content.
Sure. Would anyone like to comment on that from the audience? Should similar standards govern the interception of communications and use of metadata? I have one over here and then over there.
And over there as well.
I was involved in crafting the necessary proportion principles, and we had a specific discussion about the issue. I think our main point was that what we are really trying to address is the attitude of the U.S. judiciary in saying that metadata, which is sometimes the requirements for, or sometimes fallout from consummating communication, it is bound to be shared with a third party. Therefore, it's not subject to judicial review. That's the judicial attitude, and we wanted to say no metadata still should be subject to judicial approval, should be subject to Warren doctrine. Now, once the judge supervises this process. Once an official disinterested in the promotion of an investigation looks at both request for intercession of content and request for metadata, whether it should be, whether both requests should be treated identically, we didn't really address that. I think that one main point was that there should not be some sort of a fire break between metadata and content, but whether there should be a sliding scale where content is given more weight than metadata. I think we would have allowed some sort of sliding scale. Which means that both will be weighed in one spectrum or one standard, not under two different standards, but still will be treated differently.
Michael Wolf of Amnesty. Just follow up Brent's talking about Section 250. I think it's very important for countries or activists or leaders or civil society leaders who are facing such type of surveillance laws might be replicated to your own country. Is that do not expect such kind of legal court or administrative court protection being so-called in-state in the mass surveillance ordinance would actually protect yourself from, free from being tapped, your metadata being tapped extensively. Because like we have seen FISA court, it's pretty much rubber stamp. For 20-something years, they have only rejected something like 10 or 13 applications of court interceptions. So is the case that if we are calling for a better protection of our metadata, we have to remind ourselves, apart from those institutions, we have to have a very clear principles, applications, and some kind of mechanisms that actually work instead of being a administrative of in-state and become more of a staff.
Hi, I'm Juan Carlos from Costa Rica. I was wondering whether you have any good examples of best practices or about around the figure of the ombudsman or some different kinds of protector of the data of the individuals or metadata, content metadata. If there's some good examples or any. Not in the judiciary, but within administrative procedures that we should look at as good examples. Thank you.
Maybe in the UK, they have a separate officer who at least also publish data, but I'm not sure whether individuals can also issue complaints directly.
To add to this point about the data protection commissioners or inspectors generally in European countries are doing basically three things. One is that they are receiving some form of complaints, or most of them don't have a formal process, but one can just kind of contact to point that there is a problem somewhere. They're also ex officio examining wherever there may be data breaches, and they should have a broad remit, and it works. I think UK is a good example. It works quite well, but in many European countries they sort of have quite a broad remit. And the third thing is that they should give suggestions, advice to other authorities that deal with it, so that they can basically interact with other authorities. So I think in that sense the European models, which are fairly similar, are useful. The UK one is very good at publishing all its findings very easily available in quite easy language on the internet, which is also in itself, because you mentioned before about the difficulty in finding information. This isn't laws exactly as such, but it helps to understand the issues in a kind of easy language. May I, as I have the floor, continue? Just very briefly about the other things that were brought up here. I think it's important maybe that is whether requests are treated identically, as you brought up. That's, I would say, is a different question to whether they should be legally treated the same way, because I think indeed the whole point of what we sort of advocate for is that there should be a proper system for dealing with any requests and also proper oversight. And it may well be so that the requests are treated in a different manner, but by the same process. So I think it's important to say, I think advocating for exactly the same way of then judging the request is a different thing than advocating for the same system of it. And then also about the proper enforcement, I think this is extremely important to just underline what the second intervenant was saying, that it's one thing to create these systems, but whether they then are actually functioning. And I liked one statement from the Czech law, and I've become a big fan of the Czech law, which I actually didn't know anything about before, but it says that police, or also the other agencies that have a right, the military and civilian security agencies, but whoever has the right to ask for any surveillance must continuously evaluate whether the issuance of the surveillance and the recording order is still justified. And this is this kind of quite simple thing, but if it is also enforced, it can be quite useful, because it means that you have to, say it again, you have to formulate it again. Why are you actually doing this? So you cannot too easily just do that, and it's a little bit different now than the court enforcement, but I think any such principles that forces whoever has the possibility of taking decisions or of evaluating the decisions, that they cannot just say, okay, that's fine, go ahead, until we tell you differently. They have to, at certain intervals, say again that this is still needed because of this and that and the other. I think that can be a very useful, simple tool to at least underline how important the proper enforcement is.
Yeah, I think that's right. I mean, the request to the court in the implementation guide, in this instance, talks about the request actually having a time limit on it, and then a report back to the court in order to demonstrate how the content or the data has been used, and to show that it was proportional to the request and so on. So I think that there is if it's properly constituted, there is a legal process through the court system, which is separate to the ombudsman, but it's within the judicial process. I think the new special mandate holder on privacy, the new special rapporteur that we've been hearing about, is also, hopefully, will be a good mechanism, which is supranational, to keep national security agencies and law enforcement to hold them to account. So I think there's two mechanisms. And then there's also like others that we've seen, like, in the US, the Privacy and Civil Liberties Oversight Board, and various other boards that are connected either as judicial or quasi-judicial, but it would probably be worth doing some research on this, and maybe somebody in the room has done research on like what is best practice in terms of external and internal oversight of these issues. And it also just picks up on your question about the courts, and I think it's true to say that this implementation guideline does use the courts, and it relies upon a competent judicial authority. And I don't think we yet have an answer for a rubber stamping court. Like, I don't think we have the solution there. But what we're looking for is levels of accountability, so that law enforcement aren't able to just go straight to the companies, that they actually have to request from some other body to show why this is needed, where the legitimate aim is, what the time limit is, etc., and how it's connected to a particular crime or other activity. So, and then there was also your point about the difference between metadata and content. And just to push back a little bit, and I think I agree with you, is that what we're and the implementation guide of the necessary and proportionate principles talks about the highest standard being applied to both, in the sense that because this metadata can be so revealing, that it should have the same standard of protection as content.
Thanks. That brings us very nicely into the next point. A lot has been written about the need for effective oversight of communication surveillance, that there need to be mechanisms to ensure transparency and accountability of communication surveillance. The necessary and proportionate principles advocate for prior court approval of every order to conduct the interception of communications. And we've seen that in the Czech Republic and in Portugal, prior court approval is required for access to metadata and for the interception of communications. Let's see, the Office of the UN High Commissioner for Human Rights and its report on the right to privacy in the digital age has emphasized the need for all branches of government plus an independent civilian agency to conduct oversight of the law enforcement agencies that are conducting communication surveillance. So maybe I'll ask each of you, starting with Brett, to give me kind of your 3-minute key points on what effective oversight looks like.
Can we start down that end?
Sure, we can start on this end if you're...
I think best practice on effective oversight is that it should be in a very robust law. The body who has the power should also have investigative powers, and it should also be very transparent. And it is important that the investigative body also have access to all the relevant information. I think that are, for me, a couple of elements that are very important. And whether it should be prior court approval or not, in many cases I think it's really important to have court approval because they look at it in a different way than executive powers are doing. And when it comes to national security agencies, I think it is very good to have a combination of oversight mechanisms. So first of all, also an internal oversight mechanism, but also very important to have external. Parliament should definitely have a role, but I think that in addition to parliamentary control, you also really need an independent body. And for example, it has been mentioned a couple of years ago as a best practice. In the Netherlands, you have a separate independent committee who annually publish a report on the functioning of the surveillance and intelligence agencies.
So I'll try to mention some different things then in addition to that, which again I agree with, that I think the key thing is, you did also mention it, but it must be firmly established by law. I think that is, maybe if I would have to pick one thing, it would be that you cannot have an oversight system which by itself may look like it's maybe not properly established. Actually, and this goes back then to what I started with, talking a bit about my experiences in working in many different countries, it doesn't matter so much exactly what it is. And I think this is, again, one of these things that one has to be sensitive to when giving advice to different countries. It may look very different. It may be called something different. It may be established in a different way, etc. That is less important if it is firmly established by law, if it is independent, and if it has the proper tools to do its job, because this is unfortunately something that some governments are quite clever at using, setting up a nice system and then starving it of resources so it actually cannot do its job. Or another popular thing of less honest governments is to have a very detailed possibility to decide over the budget of an agency down to each single budget line. And this looks incredibly boring, as most things to do with numbers do, but it can actually be very important, because if you can only spend 10 euros for actually doing a job, but you can spend 50 on coffee or so, that's like, it's not going to lead to good work. So that is absolutely essential, that its agency, whatever it is, can properly operate. I have worked in a country, Bosnia-Herzegovina, which had no functioning court system when we started setting up a regulatory agency, and that was indeed a huge challenge. So we actually created a separate mechanism for appeals, which was quite successful, and this is not just praising ourselves, but this was actually tested by the European Court of Human Rights, or their special body which then dealt with Bosnia-Herzegovina, and they also found in most aspects of it were okay. They criticized some of it. But this is, of course, not ideal, but it shows this that it actually matters a bit less what exactly this body is, as long as it has a possibility of working properly and it's independent, etc. But of course, in most countries where there is a functioning court system, it's better to involve that, to not start doing something too creative, but often perhaps, yes, coupled with something different, like an ombudsman, a commissioner or so. But whatever it is, it has to be very clear what is its role, where does it come from, what powers does it have.
Agreed, for sure. And I just wanted to pick up on the point of remedy, because I think that oversight is essential, but without remedy, it's kind of, it plays a function, but it doesn't actually remediate the injured party. And if you look at the, how's that? If you look at the Ruggie principles, or the principles of business and human rights, it talks about protect, respect, and remedy. And so how does a person whose rights have been violated actually gain some form of compensation or restitution? And in some cases, it's just an apology that's required. Work that's been done with remedy and telcos has shown that, in fact, sometimes what the person whose rights have been infringed is really just requiring is just an acknowledgement that their rights have been infringed. But it can cost as well. We know of cases, there are many cases of people who are currently in prison as a result of data and information that has been handed over by telecoms or direct access from telecoms to state agencies. Yeah, so this is not just academic, this is real. This is people who are currently languishing in prison, some of whom are friends of people around this room. And so we need to look at oversight, but we also need to look at how does the two parties, the company and the state, actually respond to infringements of rights.
And I should also mention, we had discussed earlier that the opportunity for companies to challenge requests that they receive that are overbroad was something that is considered a good policy practice. But we'd love to hear from all of the brilliant minds in the room as to what constitutes effective oversight. Some ideas on effective oversight of communication surveillance.
Hello, I'm from Georgia. Mariam from Government of Georgia Administration, Human Rights Secretariat. For our example, we have a data protection agency, and we have two steps wiretapping. Because when Internal Affairs of Ministry of Internal Affairs gets a court decision, he can start wiretapping. It needs computer confirmation from data protection inspector. As for wiretapping, and for computer surveillance and internet surveillance, Internal Affairs can start surveillance after getting court decision, or in urgent case, he can start, but after 24 hours, he should get the court decision. There should be not for every crime you can start computer surveillance. There should be some crimes in which you can start surveillance. Also, that should be proportionality principle. If you can get the same information from another kind of investigation, you should take another one. It will be one of them. And to whom you are going to surveil, because it's a person who is suspected or a person who is related to the crime. And this should be considered in detail when it is in court, before judge makes decision, yes, to get order or not.
I think it's interesting, the European Court of Human Rights, when looking at the signals intelligence program in Germany, stressed the need for effective oversight of those kinds of programs and cited oversight by the Parliamentary Supervisory Board and the G10 Commission in the way that it worked in that particular context as a good practice. But I think we would all agree that the need for robust oversight of those kinds of surveillance programs is especially important. Did you want a quick comment, or can we get, okay, quick comment and then other?
Yeah, I won't go into much detail now about it, but I think this, indeed, the German strategic intelligence areas, there's provisions where it is possible to make this kind of surveillance, which is much less intrusive in the sense that it's a search based on basic keywords, and it is the telecoms companies that are in control of this and that hand over, and that they are handing over this what's called interception copy, which they have worked on before they hand it over. So they will only hand over those keyword sort of that can be monitored. But this, as I understand it now, trying to sort of quickly read it again here, is pretty much what you're actually asking for, because it's a possibility of conducting a kind of a mass surveillance, not targeted at individuals, but targeted at a specific issue in a specific area in a specific time. So without knowing who it is, but knowing that there will be someone. So I think there are good examples there. And with this oversight, as Liesl just mentioned, this German example may be actually a good model in that.
Other questions, comments on effective oversight? It must be the end of the day. I know you all have good ideas and experiences. All right, then finally, I will move on. The final point that we had talked about was the notification of users after communications surveillance has ceased as a potential good policy practice. The necessary and proportionate principles are strong on this point and outline quite a bit with regard to notifying users. German law provides that in criminal and intelligence cases, users or the customer should be notified by the government after communication surveillance has ceased. What are the thoughts of the panel? And maybe I'll start on this side with that.
Indeed, it is a good thing that people are notified that they were under surveillance. And I think it's also important that the obligation to do so is imposed on the government. Because for companies, sometimes it can be very difficult to assess whether it is harmful to notify or not. And it can also be very impractical. But it also depends on which situation. I think there is a difference in the situation where there is surveillance or whether there is a notice takedown for website. I think that's are two situations which you have to differentiate between.
I think as a principle it would be good. I think it is one of those principles which will be a bit difficult. There will be exceptions to it, and I think there will have to be exceptions to it. Otherwise, governments would not accept it or would just try to bypass it in secret or so, because it's very difficult sometimes to say when something is still ongoing, even if a particular issue of surveillance has ended, but that might not be because that whole question has gone away. So, but I think as a principle, it's part of the general idea of transparency, so why not promote it, but being aware that it will need some exceptions.
I'd probably go a little further than you two on this, because this question of notification post-surveillance, I think there's probably broad acceptance, unless there's a risk of imminent danger as a result of that notification, that the person should be told after the surveillance has taken place. But I think we need to look at it earlier along in the process, because the person who's surveilled has no opportunity to push back or to challenge that surveillance if they only find out about the surveillance after it's taken place. So that means that the burden is really on the person who's surveilled to then prove that they should not have been surveilled. And I think that that gives too much power to the surveillance bodies and to the companies. I think that the person who is a potential surveillee should have an opportunity to be able to challenge the surveillance request, unless there is imminent risk. Because surveillance is not only about it's not only about current access to data, it's also about the history of data as well and of communication. And so, yes, there are certainly instances where people should not be notified. But again, I think that should be part of the judicial process as well, and perhaps for the court to decide whether that notification should take place before or after, but certainly somewhere along the line, and my tendency would be at the beginning.
Thank you, Eduardo Bertoni, law professor in Argentina. I think that it's difficult to give arguments against the idea that after surveillance, the person should be notified. I think that this is essential, that he or she was under surveillance. The problem is, as you said, right, the problem is what happened during the investigation. And you say that during the investigation, we should move to the idea that the suspect should be notified as well, unless there is a compelling situation for not to do so. But I want to play a little bit the devil advocate here. So let's say that you are a law enforcement officer and you decide, you have a court decision that for your investigation, it is necessary to put under surveillance a specific person. But you know that you have to notify him. Why? What are the reasons for put this person in surveillance? Surveillance usually is to collect evidence in exceptional situations, because surveillance always is an invasion to privacy. The problem is that should not be arbitrary, should be under, a specific situation that allows the law enforcement to do that. But I'm not seeing a case where surveillance is useful when you notify the person who is under surveillance.
So just to clarify, it's not about the bureaucrat making the decision, it's actually about a court making the decision, because a bureaucrat, as we know, can be extremely overzealous. And we've seen it. We see it everywhere. It's like, we need to know everything about, right? So it's a court decision. So I guess the point that I'm making is more about where does the burden of proof lie, and the presumption for me, on the basis, or actually on the basis of the implementation guide, is that the presumption should lie on there being a request not to notify, as opposed to the presumption of there being notification, because largely, and it's at the starting point, is that the individual has no opportunity to challenge that authorization of surveillance. And so therefore we're all subject to a decision that's being made about us without having any opportunity for appeal until notification happens at the end, if it ever happens, according to Dan. And I guess the other point is that I think everybody who is engaged in some sort of criminal activity or national security activity already knows that they're under surveillance, right?
Well, that is a very practical situation. But again, I agree with you that anybody who could be under surveillance might have the possibility to challenge that. But if that is the case, surveillance is for what? What are you doing? Okay, yes, let's say that we agree, I'm going to notify you that I'm going to put you under surveillance, because the principal says, or whoever says, you have the possibility to challenge that. And you challenge, and you lost. Okay, I win, I'm going to put you under surveillance. For what?
No, I understand. But surveillance is not just about real-time access to communication. It's also about content it's about past data as well. So this is about access to information, not just real-time
That's a good
lawful
point, yeah.
intercept. Yeah. Or wiretapping.
Okay, we're almost out of time. Any final comments from our audience?
Sorry, I have real quick, but I understand what you're saying, but and so I think there's still a human challenge that we have to think through with all of these, because it won't be philosopher king. It'll be thousands of people who have to be able to make these decisions fairly well.
All right. Any other final comments, questions from the floor? Great. Would the panelists like to make a little 1-minute conclusion?
Sorry, to put together some recommendations to the Freedom Online Coalition countries. And it's basically on all of the points that we talked about. So on transparency, on the issue of metadata and content, on effective oversight, and also on notification. And we came to a position that we're all comfortable with across civil society and academia and corporates, and we're going to make those recommendations to the FOC. And I think the contributions that we've had have been really good, because we can kind of amend them a little bit and then send them off. I don't know if were you going to say that?
Yeah,
Anyway,
yeah.
that's my
I
final
think
thing, which is this is not just a discussion, that we're actually physically going to hand over these recommendations to the governments and the coalition.
right. So these are examples, some examples of good policy practice, not the only examples, but some things that we could converge on as good policy practice. Would you like to conclude?
Well, just to support this, and it fits very well with what we have been talking about, the need to have some principles, to have something that helps states, because I think a lot of things that go wrong are actually not, well, at least not all of it is based on sort of ill will, but there are also difficulties in knowing what to do and how to make this work. And so I think making recommendations like this is useful. It doesn't mean that we've solved the issue. I mean, unfortunately, it's not that easy, but it's a little brick in a wall of hopefully useful construction to better protect the individual's rights in this new situation we're in.
You maybe to give a follow-up on that. I recall that the GNI was created to exactly overcome the problem of companies who had to deal with domestic laws conflicting with international norms. By implementing the GNI principles, participating companies are taking concrete steps on behalf of more than 2 billion internet users. And our independent assessments show actually that it helps. Companies, by implementing these principles, are able to limit the disclosure of personal data and the removal of content. And it also shows that companies have become more transparent. So it's definitely not a whole solution, but it has an impact.
Great. Thanks so much to our great panelists, and thank you to you for joining us.